Okay, greetings, folks. Keith here, hoping everybody's having a good day, enjoying life, living life, loving life. We're coming at you tonight because you've been duped. As our brother Paul and Slade talks about the dual jurisdiction, we're going to talk about that a little bit tonight from my perspective, according to my research. And you folks know that I'm big on the words and everything, so that's what we're going to be talking about. Before we get into that, I want everybody to hit the share, like, and subscribe buttons. And, of course, if you like it enough, hit that notification bell so you get notice of the future videos. And, of course, there's a PayPal link in there for anybody that wants to share some love. Always appreciate it and always need it, helping each other out. Want to welcome everybody. Rodney Kitley, Damsel Medic, 1800 Murder. I man do not or don't understand Special K. Anybody else that's watching on Facebook, I don't know if you're there watching. It doesn't let me know, but if you're there, I appreciate it. And let's get on with it, because we're going to be talking about, like I said, the words that people are using in regards to all of the different jurisdictions. But every last one of those jurisdictions, no matter how you look at it in the commercial venues, whether it be a tax venue or a probate venue or a bank venue or a child support venue, anything in those administrative courts has already been assigned and appointed, and parties are clarified. And what's happening is that all of those contracts, no matter what venue it is, they operate under a public trust. And people don't know their position in that public trust. And so we need to learn the orientation of what and how the parties are identified. So we're going to show you a couple things here. If you look back at my other videos here recently, you'll see that I was talking about an obligor. The obligor is identified by a number. And when it comes to a trust, generally, that's the property in the trust that's enumerated. The parties themselves follow names. And so what we're going to talk about is Grantor versus Grantee, Trustor versus Trustee, and Benefactor versus Beneficiary. So let's pull it up. Let me check and make sure nobody's wanting to get on stream. Okay. Okay. This is Grantee. And you'll see this is from Investopedia. The first three we're going to go over is Investopedia. And then we're going to talk about just a plain definition. We're going to go back to a Investopedia definition. But Grantee, definition and examples in real estate. Now, it doesn't matter if you're dealing with real estate, real property, private property. Anytime you're dealing with property at all, like I said, it's the property of a trust that's generally enumerated, and it's the parties that are named. And so when we talk about grantee, we're talking about a name in a trust. It doesn't have to be limited to real estate. It's going to apply the same through everything. It's a trust definition. So it doesn't matter what kind of contract involved. What is a grantee? A grantee is the recipient of a grant, scholarship, or some other asset, such as real estate property. So again, it's the property, it's the asset, and this applies to assets in trust. Okay. In contrast, a grantor is a person or entity that conveys ownership of an asset to another person or entity, telling us that ownership is in the entity or the person, the grantee. So the grantor is conveying ownership of an asset to a grantee, who then grants it in trust to a beneficiary. Okay. Identifying the grantee and grantor is especially important in legal documents as specific duties, not general or particular, but specific. In other words, they are specified. Responsibilities, benefits, and limitations are assigned to each. Identifying the grantee and grantor is especially important in legal documents as specific duties, responsibilities, benefits, and limitations are assigned to each, the grantee and the grantor. Okay. The grantor gets an assignment of an ownership that was conveyed to him as a grantee. Now, when he wants to turn around and grant it to somebody else, he's going to convey the ownership to a grantee who then grants it. Or he's going to pass it to the responsibility of a trustee who is going to hold it until a beneficiary reaches age of attainment where he can use it. See the difference there? So when a grantor conveys property to a grantee for their benefit, then that's a simple trust wherein a trust shall not fail for want of a trustee. So now the grantor grants or conveys the ownership for the benefit of the grantee, who is now the benefactor. Pay attention. Understanding grantees. A grantee is the recipient of something granted or given. So a grantor can give something to someone else, again, without a trust, without a trustee, but done in trust form because it's simply a grant or a giving from one to another. Period. Plain and simple. Okay? The term can be used in different contexts and across different industries and institutions. Like I said earlier, it doesn't apply just to real estate. In real estate, the grantee takes title to the purchased property. So the grantor takes the title and gives it to the grantee. That's the title. He conveyed the ownership. If he conveys possession of a title to a trustee, then that conveyance of the title isn't for ownership or benefit, but actually to hold for the beneficiary. That's done in an assignment, and that assignment is a contract where that's the benefit for the trustee because he's going to get paid for his time for holding it. Okay? That's where the trustee kicks in. That's where contracts kick in with trusts, is when you have to hire a trustee to hold the property for the benefit of the grantee that you wish to convey the property to. So the grantee, once he becomes, or the beneficiary, once, or benefactor, I should actually call it, because a benefactor is going to be a living soul and somebody that can use it. And he can place the facts on the record, which is the beneficiary. Okay. So you can grant something to somebody else through a trustee who holds it until the beneficiary reaches a point where he can use it. Whatever those determinations are, the grantor makes. In real estate, the grantee takes title to the purchased property, and in a simple grant, the grantor gives the title to a benefactor who has a priority and a duty and obligation. And we're going to talk about that here in a minute when we're done with this. We're going to go to a King James Version scripture that's going to hopefully wrap it up for everybody. In academia, a grantee is the recipient of a scholarship or grant. In the investment industry, a grantee can be the recipient of stock options. So, in the investment industry, a grantee can be the recipient of a stock option. So, as a grantee, I can receive a birth certificate that I can benefit from by acting as the benefactor for the beneficiary, which is the record. But the only thing I can do in that is to reconcile the record. In other words, correct the errors in the record in the transfers of that property. the ownership and conveyance of that property. As a benefactor, I don't have qualifications to be a contractor, and I don't really have qualifications to grant the property to somebody else without reconciliation. So as a benefactor, what I have to do is correct the record, reconcile the record, and that nixes the trust. So as a benefactor, I have to step out of the benefactor, become a grantor, create a new trust, transfer it to the new trust. I hope that makes sense. Key takeaways. A grantee is the recipient of something such as a college grant or real estate property, which they are then holder of a record, that title. That's the liability. So when the benefactor gets that title, and he's got the beneficial use of it, is to hand it back with special directive to convert it to its credits and transfer the credits. You're not supposed to be holding those titles. You're not supposed to be doing it. That's the liability. Okay? A grantor is a person or entity that transfers to another person or entity the interest or ownership rights to an asset. So now we're talking interest or ownership rights. Now is where we talk about that trustee, because the person or entity transfers to another person or entity interest or ownership rights to an asset. So when they transfer the interest to a trustee for the holding for the ownership rights of a beneficiary or benefactor, the interest in it for the trustee is the compensation he gets for holding it until that benefactor attains that age of majority or whatever the discretion is. The next one is legal documents such as deeds detail the transfer of asset between grantors and grantees. Legal documents such as deeds detail the transfer of assets between grantors and grantees. That would include any assignments of trustees. If there's no assignment of a trustee, then it can't be presumed that there's a trustee. You can't just step in as a court of probate and assume that this trust needs to be probated. Okay? But again, like I said, that's such as a deed. That's a title. That's what shows that it's still in person and not in the entity. The type of legal document determines what limitations are placed on rights and interests transferred to a grantee. This is where a presumption kicks in on state ownership and easements and covenants and things like that, and the presentment that you supposedly owe taxes. See, all of that's wrong. They're stepping in as a trustee saying that as a public trustee, you owe taxes. Sorry, the beneficiary is not required to do anything. And if I'm the beneficiary by receiving a grant from a grantor as the grantee, then it's to my benefit, not to my detriment. Why are you trying to hold it as a detriment? The grantor and grantee are named in legal documents. Named, not enumerated. Such as deeds, which transfer from one party to another the interest or rights to an asset. Now it says rights instead of ownership. Think about this stuff. However, what exactly is being transferred can differ depending on the type of legal document. For example, in real estate, a quitclaim deed provides no warranty regarding the status of the property's title to grantee. This type of deed can render the grantee powerless should there be title defects, whereby no interest in the property is transferred to the grantee. Now, this is where we talk about that capital transfer stamp that's not on that deed. If it's not there, then nothing was truly transferred, and the grantee has no rights. Okay? Comprehend that. The types of deeds are uncommon between parties with no existing relationship. These types of deeds are uncommon between parties with no existing relationship. Imagine that. So let's check real quick. I'm gonna check comments and see what everybody's saying because nobody's joined me. All assets are property. All property is asset. Even your intellectual property, your thoughts are assets. And because they are assets, it's simple. They are set as is. My yay is my yay. My nay is my nay. What do you think? Yeah, it has nothing to do with creditor. It has nothing to do with obligation. When we're talking about grantor, grantee, and beneficiary, benefactor at this point, a trust shall not fail for want of trustee, then there are no obligations. It's only when we put a trustee in there that there's an obligation, and that obligation resides on the trustee only. Once the offer is made by the grantor and the trustee accepts the assignment of a contract, then he is contractually bound, and that is the obligation. It's a numbered contract. The contract itself has to be enumerated. Okay, so let's go on to the next one. Grantor, grantee, trustee, or trustor and trustee. Now, you remember the grantor gives to the grantee, right? What is a trustor? The term trustor refers to an entity that creates and opens up a trust. So if a grantor wants to give property to a benefactor, but the benefactor isn't of age and can't receive it now, he can become a trustor, open a trust, and ask for somebody to be a trustee. Now the trust is created. Now that's a legal trust, and that's for a holding, not for a transfer. That's a holding until the beneficiary can receive, who is the intended grantee. So that when that grantee, the beneficiary, becomes of age, the trustee can transfer his holding and remove his interest and obligation. Now the grantee has all obligations and liabilities to take care of that property, maintain that property, whether it be a car, intellectual property of an estate, proprietary secrets of a restaurant recipe, the real estate, whatever it is. A trustor may be an individual, a married couple, or even an organization. Individual, married couple, or an organization, saying you have to be organized under the laws of the United States in one way or another, whether you're married couple, which is a license at the state level, or an individual at the state level, and the United States federal government maintains records on you through the statistical record at the state with all of them titles. Trustors generally make contributions of property to add to the trust. Trustors generally make contributions of property to add to the trust. Like I said, the grantor is the one putting the property in the trust. When he does that, he's got to create a trust because there's no trustee yet. The trustee creates, or trustor creates the trust. So now he acts as a trustor to create the trust wherein he can transfer the property, convey the property to the trustee, who is an individual, married couple, or an organization. See the difference? The grantor and grantee are not such people or such persons. You won't see those terms in there. So again, we see that an individual, married couple, or an organization is under a contract with the United States under federal acquisitions regulations, 48 CFR 52.212, wherein it states contract terms and conditions are required to implement statutes, executive orders, hyphen commercial items. So that statute at the state level that says you have to get a Social Security or driver's license or anything, a marriage license, those are all dual jurisdictions that you've been duped into believing that you have to take on. The grantor is the one that conveys property to the grantee. The true grantor in all cases, is this thing everybody believes is God. This can be done by donating, contributions, Social Security contributions, FICA, federal insurance contributions. Yeah, those are contributions, and you're contributing to that trust. This can be done by donating money, gifts, and assets to other individuals. Trustors normally set up trusts as part of their estate planning. Trustors do this by transferring their fiduciary duty to a third-party trustee who maintains the assets in the trust for the benefit of the beneficiaries. So now we have an aspect where if you're a grantor and you've got property, but you've got no one to grant it to yet, you can open a trust as a trustor and assign a trustee, somebody of your liking, an individual like yourself, the person, your own person can be the trustee. Now that person is a creation of the United States by the name and enumerated. And you can reconcile that record, merge it into a new name, and use that name. However you want to do it. But it's got to be a fictional entity. That's where you place the ownership and holdings of property, because then they can't harm you yourself. They have to destroy the trust. That's kind of hard to do if it's done right. Pay attention. Key takeaways: a trustor is an entity that creates and opens a trust. So the trust isn't there until somebody becomes a trustor. Trustors can be individuals, married couples, or organizations. Again, this is a takeaway because it's got to be in that commercial capacity as an individual, married couple, or an organization organized under the laws of the United States, partaking in the United States trust, contributing and donating to that trust. They say you're required to, but this says can. This can be done by donating money, gifts, and assets to other individuals. Trustors generally make contributions of property to add to the trust. So if you take all of your money and all of the gifts and all the property that you received in your life and you put it in trust to protect it, and you assign yourself as the trustee and you don't have children yet, it's held in trust. The trust is still going to protect it. And you can still name a beneficiary. You can name a sister's child or a grandchild, or a cousin or somebody like that in your extended family. You can name a friend a beneficiary. Doesn't matter who you name as beneficiary, and that doesn't have to be disclosed. Matter of fact, that's one of the protections of a trust, is the beneficiary is protected as well as the property. Undisclosed, not disclosed. Trustors work with trustees to safeguard and distribute their assets. Trustors work with trustees to safeguard and distribute their assets. The trustor and their assets, and he works with trustees to safeguard and distribute, including the money and property. A trustee assumes the fiduciary duty from the trustor. So when you become a trustee, you take on a fiduciary duty to make the proper assignments. If you do it properly, the trustee can take on those fiduciary duties properly and safeguard the trust. This is why it's important to realize who's taking part in this and what their names and identifications are. The trustors are also referred to as grantors or settlers. Just like I said, the grantor is the trustor. The grantor becomes the trustor, and he settles the trust. Okay? Let's go on to the next one. But before we do, let's check with the panel again. Nobody there. Comments. When one contracts with a corporation, that the grantor, lender, vendor, or whatever the scenario would still have an obligation. Yes, the contract is the obligation. A trust does not hold obligations unless there is an assignment of a trustee. Otherwise, it's a simple grant and it's a gift. There's no obligation in a gift. Okay. Do I need to make an affidavit of gift for donations to protect assets? Not unless someone tries to make a claim against it, and then that's when you have your two witnesses come forth, the one that made the gift and the one that received the gift. This is what I went through with PayPal. I said, you call up, if this goes to court, we can contact each and every last one of those people that donated, and we can ask them if they thought they were making a payment or a donation, if they knew the difference. Because every last one of them thought they were making a donation, because that's the only thing I've ever asked for. I've never asked you to make a payment for anything. I've told you I don't offer anything for buying or selling, import or export. Everything is free education and review for opinions and commentary. That's it. You know, we don't buy and sell anything here. So anybody that wants to portray that it would be something different, it would be me, and that the party that gave it to me, that would be firsthand witnesses that would say otherwise. That's how simple this is. You cut out the middleman. You tell the trustee that's operating as a trustee that you're not part of that trust, and that gift was not part of that trust. Okay. Very intelligent asks, what kind of stamp needs to be on the deed? That's a $10 transfer stamp. That's the tax duty stamp. Whatever year it was, you'll have to look it up. Tax duty stamp, and in there you'll read that there's supposed to be a $10 transfer, a capital transfer stamp of $10 on that title. If that's not there, then there was never an actual transfer. It's actually called a capital transfer stamp. So think about that. So let's get on to the next one then. Is a beneficiary. How they work, types, and examples. A beneficiary is a person or entity who is designated to receive the benefits of property owned by someone else. There's no obligation there, just like you saw in the grantor, grantee. There's no obligation here. The only time you'll find an obligation is in the trustee. Beneficiaries often receive these benefits as part of an inheritance. In other words, generally it comes from a family, dad down to son. Beneficiary can be designated in the documents relating to a life insurance policy, a retirement account, a brokerage account, a bank account, and other financial products. So this is telling you, when you go to that bank and you open up an account, you're buying a financial product. You go to the insurance company, you open up an account, you're buying a financial product. You're buying. It's important to designate beneficiaries for your financial asset. And if you're a beneficiary, do you have to buy something for your benefit? You can buy a car for your benefit, but you should know how to buy that. See, it's not actually a purchase, it's a transfer. And so what you need to do is learn the paperwork so you can transfer appropriately, because you really can't buy it. And according to the United States obligations and other securities of the United States under 18 U.S.C. 8, you can use stamps and other representatives of value. Read that, 18 U.S.C. 8, and you will find between comma and comma, all lowercase, it says stamps and other representatives of value. So you don't even have to use the United States stamp. You can make your own homemade $10 stamp for that capital transfer stamp. Guaranteed. You just have to know how to do it. You have to know how to impress upon them that you can do the same thing they can. You can make the same kind of financial products. A stamp being a financial product at the upper level. So that they can be distributed according to your wishes when you pass away. Notice they didn't say die. I spoke on this before. You pass on. A beneficiary is an individual who receives a benefit which is often a monetary distribution. Doesn't have to be. Distributions can have tax consequences. Beneficiaries who inherit a retirement account may have various options for the distributions of its fund. Options for distributions from inherited IRAs depend on whether the beneficiary is an eligible designated beneficiary or a designated beneficiary. What's the difference between an eligible designated beneficiary or a designated beneficiary? You can change the beneficiaries on financial accounts at any time. Do you think they're changing the beneficiaries on those financial accounts any fucking time they wish? Are you catching on, people? Though doing so requires completing and returning relevant paperwork. Relevant. As long as they have a fiduciary power, it's relevant. And as long as they think they're doing what they're supposed to, it's relevant. And as long as you don't know what they're doing, it's relevant. Any person or organization can be named a beneficiary to receive your property after you pass away. The individual who owns the property or the benefactor, as I've said, the beneficiary is the name, not the living man. Beneficiary's name is only in the record. You don't see it tattooed on him, do you? This is why I say I don't have a name. Show me that I have a name. Show me that I am holding a name. Prove that I can hold a name. The individual who owns the property or the benefactor can put various stipulations on the disbursement of property. So the benefactor can make the stipulations over the trustee, right? Do you comprehend now? See, the trustee has an assignment to hold it. He can't distribute it. Okay? He has to name somebody else as a beneficiary so they can distribute it. You know what that prosecutor does in the court? He names the court the beneficiary so he can distribute the property. And you don't know a fucking thing about it. These might include the requirement that a beneficiary attain a certain age or be married before taking control of the inherited property. Certain age or certain requirements for the benefactor to take control. Also, there can be tax consequences for the beneficiary when inheriting certain financial assets. For example, if someone is the beneficiary of a life insurance policy, which is the obligation or security or other security of the United States, then there's a tax implication. And you may have to avoid it. Not evade it, but avoid it. Not unlawful. It's useful to know that while the principal of most policies is not taxed, the accrued interest might be. So if you name a trustee as a public trustor, a bank, a lawyer, an insurance agent, there's going to be an accrued interest because they're going to maintain an interest themselves for compensation to hold it while you do what you do as a spendthrift. Okay? Failure to name beneficiaries on your financial accounts can result in the financial institution that holds the asset having to make decisions about the distribution of the assets. By benefactor for beneficiary. Get it? That's the distribution. By benefactor for the beneficiary. Okay? Failure to name beneficiaries in a will can tie up one's property in probate. See? Failure to name beneficiaries in a will can tie up one's property in probate. The only way it can tie up property in probate is if that will is stated by someone that is passed away. The living man cannot be placed in probate court, folks. Okay? The living man is the benefactor and the beneficiary himself. So failure to name beneficiary in a will can tie up one's property in probate. What's your name? Do you have one? Did you name yourself? Did you go through reconciliation? Did you create a new name? Did you resurrect the old name and merge it into the new name? You know you have that power, right? Potentially for years. It can leave the decision about how to distribute your assets up to the state in which you live. And that's what they're doing. They're distributing your assets. They're taking the benefit. Okay? In either case, the people to whom you wanted to provide financial support after your death may not receive it, or they may have to wait a long time for it. Beneficiaries designated on the paperwork for financial accounts override any beneficiary listed in a will. Beneficiaries designated on the paperwork for financial accounts override any beneficiary listed in a will. Beneficiaries designated on paperwork for financial accounts override any beneficiary listed in a will. But they can't override the benefactor. They cannot override the benefactor. Get it? When you pass away without a will in place, you're deemed intestate and your assets are distributed not necessarily to your chosen beneficiaries, but according to state inheritance laws. And according to their state inheritance laws, they send out a notice, hey, this guy died. We don't know who the beneficiaries are. Are there any beneficiaries? And if no one steps up, they're designated the beneficiary. Pure and simple. Why beneficiaries are important? It's important to designate beneficiaries for your financial property so you can feel confident those people whom you've decided your money should go can be assured of receiving it. That's why I tell you, it's all a big insurance scheme. It's all contracting, and that's an insurance scheme, including the health insurance. By naming beneficiaries, you control what happens to your money and clarify the matter for all who may be involved. Clarify. When you go to customs, they ask you, have anything to declare? Yeah, I need to clarify who the person is. It's not me. Having beneficiaries simplifies the settling of your estate and can reduce the potential for stressful situation for those you leave behind. Beneficiaries designated for financial accounts such as an insurance policy or retirement account, Social Security, aren't affected by changes to a will. These direct designations take precedence because it's their account. It's not yours. It's a probate account, not yours. You get it? The only thing you can consider your property is things that you put in your will. And you have to name a beneficiary. And until you have beneficiary, you can name yourself as a beneficiary. Benefactor gives to the beneficiary. We're going to see that as well. The names of beneficiaries in financial account documents remain private. The names of beneficiaries in financial account documents remain private. The benefactor is public. Like I said, the beneficiary remains private. A will becomes public record and can expose heirs to public scrutiny. So you make your will, you make it public, and it's the will of our Father which art in heaven. And you already know who the beneficiaries and benefactors are both. Types of beneficiaries. The primary beneficiary is the first choice of beneficiary made by a financial account owner. So the first choice of beneficiary made by a financial account owner is the legal name. That's the first account made. It's made in the form of a legal name. It's made by the Social Security Administration, where they take the given name and the family name and convert it to the legal name in construct of a first and last name. Okay? They created that account. It's not yours. While other beneficiaries also may be listed in account or estate documents. So when you get that birth certificate, look at the top, it's going to tell you the state. Like I said, the state's acting as a beneficiary as well. That's a Sedeke V trust or Sedeke trust. It is a dual beneficiary. It is a co-beneficiary, co-trustee. This person or organization will receive all the assets in the account. Yep, they receive all the assets in the account. At the enumeration at birth, there was a transaction made that never transferred any property. This person or organization will receive all the assets in the account. There were no assets in the account when you were born. You had no assets. It wasn't until you created the Social Security account at the age of 18 and started claiming these assets. The income, the car, established a bank account to hold those assets. You're the ones doing this because you don't comprehend what's going on. A contingent beneficiary is a secondary beneficiary. They receive the account benefits only if the primary beneficiary is no longer living or cannot be located. And since the Social Security account can be located, and again, it's not your account, it doesn't have to be a living person. A person isn't living, it's still a person, and that person can be located. You can name more than one contingent beneficiary and how the assets would be divided between them. How to choose a beneficiary. Beneficiaries should be designated for all your important assets, including property, insurance policies, retirement accounts, brokerage accounts, bank accounts, and more. You shouldn't have all of those. If you have a good, solid private trust, you won't have any of those. You'll have a trust account with the proper people. And that account will be for exchange of credits, not use of obligations and other securities of the United States. That would be fraud. Get it? It's commingling of funds. Commingling of funds that belong to the United States as if though they're assets of the private trust. Can't do that, folks. You got to be gold and silver. You got to convert that shit. You understand me? When selecting your beneficiaries' assets or assess the relationships you have with family members and who may need your financial help, you may want to consider family pets who may need your protection. Review those outside of the family whom you'd like to care for or reward for loyal services through the years. Jerry Springer had a daughter that's very well off to do, has her own life, her own property and everything, and he didn't leave much to her in the will. Matter of fact, he left most of his stuff to his adopted daughter, who doesn't have much. So again, like I said, you don't have to choose it. You don't have to give it to family members, and you can distribute it between them however you like. When selecting beneficiaries, let's see. Look at organizations that you've supported over time and whether they can use your financial support. There's a good one. If you find your community lacking in something, it's always good to give to the community, because that community is going to turn around and get back to you in trust. And again, you don't give by giving Federal Reserve notes or stuff. You give by transferring property, by converting the proper credits for the purchase of property so that you can then donate the property. Designation process. Upon first opening your financial accounts, notice it says it doesn't say bank account, insurance account, and stuff like that. So like I said up here earlier, it says your financial accounts. And I urge everybody to set up a financial account with the Postal Service, an online electronic funds transfer account as a trust account. It's known as the Electronic Payment Systems account. And I've already got mine established, the Keith Orton Little FBU trust account as an online postal account. Financial account. Upon first opening your financial accounts, companies ask that you provide beneficiary information. If you didn't provide it at that time, you can request a paperwork that allows you to designate one or more beneficiary. Fill it out, sign and date it, and return it to the company. This can usually be done online or in person. Maintain a copy of your files. Okay. So when it comes to the written will, I've got my written will on my site. It names, I've got an expression of the trust on my site, and it names the beneficiaries. My living will explains how it protects everybody that wants to be involved in that same setup. I stand by my word. Knowledge is the true benefit. Let's double check here real quick. Okay. Yes, Jerry Springer died. Magna Carta and Charter of the Forest explains a lot with the Seneca Trust. Yes, 1666. After 1665, the Great Fire of London, wherein they already suffered a year of infestation of the Black Plague and the rats from 1664 until 1665. And then in 1667, they had the Corporate Protection Act. Imagine that. That was the same time that the churches all handed over their records to the local civil authorities. Okay. Let's see. All right. Well, let's go on to the next one. Told you the benefactor versus beneficiary. The benefactor is the giver rather than the getter in any given situation. The person or thing that receives or derives benefit is the beneficiary, or the one that receives advantage or enrichment from the benefactor. So in all cases, only a man can give something. So it's only the man that can be the benefactor. And if you give something to a record, in other words, I name a piece of property, I put it in a document, I assign that document to a trustee, and I have him hold that document and put that property in escrow in somebody else's holding. They've got it in a storage shed. The trustee is holding the interest in the title. Okay, the interest in the property that was titled in that document. He holds an interest in the title of the trustee. For his compensation to hold that document as proof, to step up on that stand and testify if anybody tries to breach that contract or breach that trust. He's got a contract to uphold the trust. That trust obligation is far superior than that contract obligation to designate another beneficiary or any other beneficiaries. They better not get caught doing that in my case. I'm going to point out the problem. The state can't be the benefactor. They can only be another beneficiary. And the beneficiary cannot make those stipulations. Only the benefactor can. The beneficiary only receives. He cannot give out. Therefore, he cannot turn around and give a directive. Only the benefactor, like I said earlier, only the benefactor can give the directive. And the last one. Remember I said we went over obligor earlier? And an obligor is known as the debtor, and they are identified by a number. I've shown this many times. The number is the Social Security number without the dashes. Again, the Social Security number on the front of the card is the administrative side. The number on the back, you take that letter and convert it to its numerical equivalent according to the alphabet. It starts out with a letter, so you convert it to its numerical equivalent and then add a 0 to the beginning of it, and that's your judicial account prepaid number. I've proven this on homemade stamps. You're dealing with the judicial office at the post office, and that's where the judicial account sits. The administrative account is through the Social Security Administration, and that's why you use the Social Security number. But again, in all cases, they convert that number to the obligor number by taking out the dashes. That's an unlawful conversion by your unknowing that they did that. Only if you know that that's done can they get away with doing that properly. Otherwise, it's malfeasance of trust by breach of contract, because there was no contract, and that means they breached the trust, and the contract they're trying to enforce as an investment in their trust is not valid. An obligor, also known as a debtor, is a person or entity who is legally or contractually obliged to provide a benefit or payment to another. Remember that given name and the family name was converted to a legal name. An obligor, also known as a debtor, is a person. That was the creation of that person as a debtor or entity who is legally or contractually obliged, and you are not obliged. Impossible. Impossible unless you are organized under the laws of the United States, which includes 12 U.S.C. 614. You have to be organized with the Federal Reserve in order to be able to handle one of those obligations. And even then, you can only use it as an advance from one financial institution or one Federal Reserve institution to another as a Federal Reserve agent. But what happens is when you're born, that enumeration at birth, the state claims that you're a resident. They claim that because you were born, all of a sudden there is a necessity deemed for your residence. Federal or resident. No person shall reside within the zone except federal, state, or municipal officers whose resident presence is deemed necessary. So if that's so, they claim you to be a resident at enumeration at birth at the state level. In a financial context, the term obligor refers to a bond issuer. Did you issue the bond? Did you go out and print up a nice bond and issue it? Or did the state issue that bond? Who is contractually bound to make all principal repayments. Did you pay them? Do they owe you a repayment because you weren't truly the trustor or trustee? And interest payments on outstanding debt. Interest is in the United States because as a resident of the state, that is a false record, and the state made a claim upon all those donations that you made to the federal government to match those funds. So what did the federal government do? They matched those funds. Now the state's got to pay you back. Do you think they're going to get those funds from the federal government? Or did they already get them as matching funds and now they got to repay you? This is Investopedia. This is for investors. This is what they tell investors. This is how they operate. Hold them to it. The recipient of the payment or of the benefit or payment is known as the obligee. The recipient of the benefit or payment is known as the obligee. So if they receive the benefit of the Social Security payments and the FICA, financial or federal insurance contribution, then they're the obligee, not you. An obligor is a person or entity who is legally or contractually obliged to provide a benefit or payment to another. So as the clerk, court registry investment system, when you go to the court and they put you down as an investor, a firm name with the obligor number, the Social Security number without dashes, they are legally and contractually obliged to provide a benefit or payment to you as an investor. If you go in there and you're the investor, you're the principal. So they owe you the principal. Okay? Make all principal repayments. You pay those fines? Did you support that bond that they issued? They're the ones that issued the bond, right? At the clerk? And they use the state laws and codes to support that? Think about this. An obligee is a person or entity receiving the payments or who is owed the obligation. Who is owed the obligation, not the benefit. So if you're not contractually bound, you're not obligated. An affirmative covenant is something that the obligor is required to do, such as hit specific benchmarks. All marks, like signatures. In family law, there are certain cases when a court order requires one of the parents, the obligor, to pay child support to the other parent. This is a false statement. Requires one of the parents, the obligor, to pay child support to the other parent. This is a falsity. This is lies. This is not correct. Whatever you want to call it, it is wrong. The obligor is identified as a number in all cases. The obligor is identified by the enumeration of the record that has the name of the obligee. That birth certificate, the first name, that's the obligee. Understanding obligors. An obligor is a person who is legally bound to pay another person. Debt holders are the most common types of obligors. Debt holders. What do you got in your wallet? You got Federal Reserve notes in your wallet? Did you know you owe a debt to the United States by holding those? That debt is a prison sentence because that's a felony. 12 U.S.C. 412. They are for advances from Federal Reserve institution to another Federal Reserve institution by Federal Reserve agents and for no other purpose are allowed. You're holding them in your wallet? That's a felony. That's what you owe to the United States. That's the debt you're holding. However, in addition to the required repayment of interest and principal, repayment of interest and principal. So now we remember the Social Security Administration got a matching fund from the United States. So you put everything in the interest of the United States. So now the state has to pay you back the funds that you paid in, that they claimed were theirs, that then they turn around and got the federal government to match. So now they have to pay that back and you back. Many holders of corporate debt are also contractually required to meet other requirements. For a bond holder, these are called covenants and are outlined in the initial bond issue between the obligor and obligee. So when you get a birth certificate from the state, you're not holding it. You are now an obligee. It has your name on it. You now have a covenant and contractually bound to fulfill your holding and pass it on to the beneficiary. Guess who the other beneficiary is? The United States and the interest. You received it, and it's a benefit to you, and you get to use it as that benefit by directing the interest to the United States so they can take care of their obligation and make sure that the state comes back and repays me and them. Trading with the Enemy Act. Obligor in corporate settings. Covenants can be either affirmative or negative. An affirmative covenant is something that the obligor is required to do, such as the need to hit specific performance benchmarks. They have to make the payment. They are the obligor. A negative covenant is restrictive in that it stops the obligor from doing something, such as restructuring the leadership of the organization. So when you go down and you fill out that SS5 application, they give you a Social Security number, never tell you a thing about the obligor number, which is the Social Security number without dashes. And then they tell you go ahead and use that number down at the local hospital and the the post office and people like that, government entities that are allowed to ask for it, you go ahead and give it to them. Yeah. There's 35 codes that tell you that says you shouldn't be using that number. Again, that's on the front of the Social Security card, and that's the administrative side. You should be using any number. It should be the one on the back after its conversion for its prepaid account. Since the bond issues are contractual obligations, and remember, it's the issuer of the bond that then is obligated. So they become the obligee required to make the payment for the obligor. Obligors may have very little leeway in terms of deferring principal repayments, interest payments, or circumventing covenants. Why? Because the obligor really can't do anything. It's a number. Remember this stuff, people. Since these bond issues are contractual obligations, obligors may have very little leeway in terms of deferring principal payments or principal repayments, interest payments, or circumventing covenants. Can't do it. Expose that number. Like I've said many times, that these people are doing things behind your back, right in front of you. Get rid of my background here. And we're going to show you. Right there at the top. This is the courthouse paper, financial index. And you can see where they converted and used the firm name, L-I-T-T. Not L-I-T-T-L-E in upper and lowercase, but L-I-T-T in all uppercase. That's a firm name. And then you see they notified and identified the obligor as a number. Okay. See if I can get this set up right. Where am I at? Okay. That's a court document. Okay, local county courthouse. This is a prescription. They're using the firm name and an obligor number. They're not using the legal name. They're not using the given name. They're not using the family name. They're all conversions. And if you don't know it and they didn't tell you about it, it's an undisclosed, unlawful conversion. If you think I don't know what I'm talking about, sorry, I don't know how to explain it to you, except otherwise do this stuff yourself and learn how to enforce it yourself. Why do you think 7 years now down at the local courthouse, they've got 11 cases where I signed UCC 1-308 and didn't go in and make any payments or anything? See them? There's 11 cases there. From years back. Because what they pose as my obligation is false. Called up the Treasury Direct Offset Program several times to ask them about it, and they assure me many times. I call every 6 months. And they've assured me every time there is no such debt. Why is that? Suppose if I look up my registered the registered selective service number. When I get on there, they're going to tell me to enter my Social Security number without dashes. Check it out, guys. You want to look up your selective service number? Put in, how do I find my selective service number? And it'll take you to a site where it's going to tell you, Social Security site, of course, and it's going to tell you to enter your Social Security number without dashes. People think you're having fun in this life, and it's all a bunch of Looney Tunes. You're right. Bunch of Looney Tunes. You're a bunch of characters, cartoons, and you're being played. You're being played every time you turn around. You're being played. When you go to the hospital to have children, you're being played when you sign your children up for school, public education, General Education Provisions Act. It's a military provision. You guys have all been duped just like I was. My apologies. If I'd have known this stuff longer, I'd have been speaking out on it much sooner. But El Perro, do you get food stamps, welfare? No, none. That would be taking on a benefit of the state and admitting that I'm part of their administration. Again, Social Security Administration. What the fuck do you think they're administrating? They're administrating a false estate and claiming that it's your estate and that somehow they got it. No, it was a creation of the state to begin with, to get you to believe that you have something and they control it. And then in your upbringing, it's because of that you believe they control you. It's stupid. Yes, firm names, DBA names, all of that. UCC 1-308, all rights reserved. That's what I signed on those 11 tickets and never showed up in court. And this is in concurrence with personal jurisdiction. Yet you see they still adjudicated them as if though they had personal jurisdiction. And I can prove they didn't. And they will have to agree that, yes, you're right. You're correct, Mr. Little. We couldn't possibly have obtained personal jurisdiction if the defendant never voluntarily appeared in court. This is stuff I've researched and I know off the top of my head. They cannot get around me anymore. I dare them to take me into court on a bench warrant for failure to appear for jury duty, wherein the judicial judge or judicial attorney or whoever made the decision said that there's no long title, there's no charges, no bond found, no finances, and yet issued a bond. Remember who the obligee is? The obligor? Yeah, it's the bond issuer. So did I issue that bond? So am I obligated? And then they sent that warrant over to the sheriff. Told him to go get that person. Try it. See, I already sent him a little warning. King James Version, Deuteronomy 24:7. Anyone that would be caught stealing the brethren of the children, any of the brethren, I want to make sure I get this exactly right. If a man be found stealing any of his brethren of the children of Israel, and maketh merchandise of him, or selleth him, then that thief shall die, and thou shalt put evil away from among you. So come get me. Come kidnap me and make merchandise of me after you say there's no financials, there's no bond, there's no charges, there's no long title. Come get me for that $350 bond and make merchandise of me, bitches. You got to learn how to stand up and be that alpha. Otherwise, they're going to treat you like a beta every time. So let's look at this thing in all the lands of your possession and how powerful you are in this Grantor Grantee setup. Pull it up here. One last thing here to share with you in King James Version of the Bible, which is at Leviticus 25, verse 23. The land shall not be sold forever, for the land is mine. For ye are strangers and sojourners with me. That means everywhere you go, you're with him or he's with you. He's the grantor. He's the one that granted you life. He's the one that granted you use of the land in this world. We are in this world, not of this world. And he granted you use of everything here. Unlimited. Full dominion. Eminent domain. and in all of the land of your possession, ye shall grant a redemption for the land. If thy brother be waxen poor, and hath sold away some of his possession, or lost them to the state, and if any of his kin come to redeem it, then shall he redeem that which his brother sold. You have that power if you learn how to use it. You have that power if you learn how to trust in every word of God, for it is pure, and it is a shield unto he who put their trust in God. Don't trust another man. Don't ever do it. Don't trust me. Don't believe me. Don't believe your neighbor. Don't believe your government. Don't believe your mother, for crying out loud. Learn how to do this research so you know. Otherwise, you're going to try to build some kind of trust and assign a trustee, and that trustee is going to know more about that trust than you do, and he's going to take everything from you. It happens every day. Like I said, it's called commingling of funds. You start saving money, Federal Reserve notes in your trust, that's commingling of funds, and they will get you. You're a thief. For no other purposes are they allowed. Why are you using them as your assets? Dummies. You big dummy corporations. That's what I call you. What's going on, Special K?
Hey man, how you doing?
Good.
Thanks for all your information, man. You blow my fucking mind, dude, with this shit.
No, it's not me. All glory goes to God, and all I'm doing is showing you where it's all at.
I know, man, but nobody else knows about this. It's just like,
well, no, because they don't sit down and do that study. Like I said, don't believe me. Do your research so you know.
Right, and I've been doing I had a court case for that suing the thing I was getting sued for, and I guess they had a 66-page document that I never received, and I'm pro se in there, so the judge was like, well, she didn't get it, so this could call for an appeal, and
well, yeah, especially 68 pages. I've never heard anybody issuing a 68-page document from court.
66 pages. It has all of my fucking all my debt was sold, so I didn't see any of this, and everything they had sent me since I was summoned 3 years ago. I sent in my response, all that shit was always through the postal mail, and I showed the judge. I'm like, Judge, this, Your Honor, everything has been sent through postal mail. I've never gotten anything electronically. Now all of a sudden something is sent electronically. What's going on here? And he's like, just to be fair, this does sound odd. And he was on my side. He said, we're going to have to continue this. I'm going to give you give you more time to go over the 66 pages. The judge had it. They had it. That's, what is that, exculpatory evidence?
Yeah, and the exculpatory evidence is what I just gave you. The obligor is identified by a number. Can you confirm, sir, that the court registry investment system in this case has me listed, or would list the party as what's your last name?
Loy, Loye. It's Kristen Loy versus
Loye.
Loye.
Would the court registry investment system have the party named by the firm name Loye in all caps, and the obligor identified as, and then read off the obligor number, which would be your social security number without dashes? You ask them that in that court, and they tell you no.
See,
that would be a straight up lie.
A lot of this shit I'm going over it is redacted. It doesn't say how much my debt was bought for. It doesn't should that shit?
Well, it doesn't matter then. It doesn't matter. It's telling you that somebody else bought the debt. If they bought the debt,
twice.
Yeah, if somebody else bought the debt, then once the debt has been sold, all parties are released. On it,
right?
Yeah, you don't have to sign on it. They sold the debt. They sold it out from under you.
Right. But that's okay. I Googled that and that's accepted supposedly.
That's fine. They can sell it, but they can't hold you as the obligated party anymore.
Under USC 5430, I have it written down, but I don't understand how to present that. And I've been Googling it. The 2B, right? That one?
No, you're when they're trying to claim that you have a bad credit score and that you owe this credit card or this company.
They have a witness too, because they started the process.
Yeah, get on the stand and claim that. Get on the stand and identify me as the obligor. I dare you. I dare you.
I wish you were my attorney.
You're the witness for the state. Get on the stand and clarify that I'm the obligor.
I am the witness for the state because I had to put my hand up and we were.
No, I mean for the other card, the opposing party. I dare the opposing party to get on the stand and identify me as the obligor. I dare you.
But there's an obligator in this situation?
The obligor, yes. They're saying you are obligated on that contract. You're not. You're identified by a name. The obligor is identified by a number. I dare you identify me as the obligor. I dare you. Your Honor, I require to have this man go back to school for English language. He doesn't understand English. This man is incompetent to hold the job he has. He's going to go around and identify me as the obligor when the obligor is identified by this number, da-da-da-da-da.
Damn. Do you know what a charged off debt is? Does that have anything to do with it? Because I have no assets, no money. I show them my bank accounts. I tried to settle for
it's a delinquent debt.
It's a
it's a delinquent debt. Remember what we just read?
Kind of. I wrote notes.
Yeah, you tell that judge, I want to hand everything over to the interest of the United States under 50 USC 4305 to make sure that the principal gets repayment. To make sure the principal gets repayment. 50 USC.
I wrote this down, but I don't understand. All those words is like one sentence.
50
and then
USC.
2B, right?
Right. 50 USC 4305 2B. Under that directive, I require the interest to be placed in the name of the United States so that they can take care of their obligations and other securities, making sure that the principal gets repayment.
And they have to repay me. Get the fuck out of here.
Everything you paid. Unemployment or taxes, education.
I paid every single
fines, fees, penalties, registrations, licenses.
Yeah. Everything.
You weren't required to pay that.
Because it's a junk debt collection buyer, Midland Credit Management. I looked them up. They've been sued by the feds for like 12 fucking times.
And the interest over to the United States. I demand this go to the Supreme Court right now because I'm being abused in this court. You as a judge already know that the obligor is identified by a number. I demand it right now or I'm coming after you. You're supposed to know the law. You're supposed to know these financial institutions and how it works. I know the obligor is identified by the number, the Social Security number without dashes. You know that as well as I do. This man granted you a beneficiary position, and you're using it against me. You either hand this over to the United States right now in the interest of the United States so that the principal can receive its repayment, or I will have your ass hung. You treasonous bastard. I wouldn't say that. But I'm giving you the sense that I would.
It's going to be through Zoom still, okay? But this is the thing. Like, should I cross-reference the fucking witness at all? Because, like,
no. I wouldn't recommend anything but going in there and letting them know that you know the obligor is identified by a number. And you will call me for as an expert.
What if they don't know what the fuck I'm talking about?
You can call me as an expert witness if you want. You can get me in on that Zoom to explain it if you want.
Oh my God.
I'll show them right in their own government publishing office style manual where the obligor is identified by an R mark. That's the parenthesis capital O, little o.
And I hate that, like, I don't have any, literally, like, I don't have any money to fucking give, dude. Like, this is, and I don't have
Listen,
anything.
if you get repayment, you can pay me then, right?
I don't see how I would get repayment because I stopped paying the credit card. And it went to collections. Then
Okay.
I put 3 more.
But did you make credit payments before?
Every time until COVID hit.
Okay. Did you know you're not required to? Did you know that you got induced into filing for a credit app or a credit loan and weren't required to?
Yeah, the name of the credit card.
Did you know that when you gave them that social security number, they also converted it and used it against you as an investor? That is not your account. You did not open an account. They have the account. They put your name on an account. That's it.
But at that time, I didn't know that. And I
exactly, and that's what makes it fraud. That's what makes. Yeah. That's what means they have to repay you.
Oh my God, bro. So this is so fucking.
See that parenthesis around the O?
Yes. Yes.
When you look up the government publishing styles manual.
Like, I'm trying to look for any error in this fucking 66-page thing, because the lady who I watched for 10 minutes was like, don't admit that you paid your debt. And that's what I did wrong. But now when you're telling me all of this, like, I was thinking I'm being honest. Yeah, this is my debt. And she was like, you should always claim this. You didn't know it was your debt, you know? And that way you have time and you can dispute it and you can call them for harassment. I learned all this shit after. They were calling my parents' house like 20 times a day. And after 9 p.m., which I learned that was fucking...
Government styles publishing, U.S. government publishing office style manual right here.
What is
signature marks, etc. Unless otherwise indicated, signature marks are set in 6-point lowercase in indented 3 EMs. Figures indicating the year should follow the jacket number and signature marks. When the all mark,
that's the same symbol you were talking about. Yep.
And signature or the imprint and signature appear on the same page, the signature line is placed below the all mark or imprint. See Rule 2.113. The imprint and all mark are not used together on any page. If one is used, the other is omitted.
Oh my God, dude.
So, when you sign a document,
and my signature,
they create another document. You gave them a social security number and signed on it. They create another document, and designate a different beneficiary and convert that number so that they can use that number as an investment for their benefit.
Dude, when I see like they sold it 3 times, I was like, David Young, and then I'm looking, I'm like, it should be printed and then it should have his signature. And then this guy's got 3 different titles. Like, I'm trying to find, and then there's a third party involved. Like, they sold it, resold it.
Another good question is, tell you what, Your Honor, if I lose this case, are you telling me I'm required to pay? Would you tell me I'm required to pay this through an obligation or other security of the United States? Because if not, then I have no way to pay it. There's no money.
I'm collection proof.
If not, then I have no way to pay it. That means that if you direct me to pay, then I have to put everything in the interest of the United States so they can pay it. I still can't pay.
Right. I know.
By using one of those Federal Reserve notes or an obligation or other security of the United States, I'm using one of their instrumentalities in creating a debt on their ledger. You would have to talk to them about payment again.
I have no money. I mean, they know this. I don't even know why they're suing. They have.
It's not a matter. Listen. It's not a matter of not having the money.
They could still put a judgment against me even after I responded.
It's a matter you don't have a way to use what they tell you you're supposed to be using because it's a violation of federal code.
Oh yeah, that's why you.
Your Honor, if I came in tomorrow with $325 to pay this $325 debt, would the clerk accept it? Oh, I'm sure. Your Honor, did you know that if I did that, it would be a felony? Whoa. That's when you bring up 14 or 12 USC 412 and show him that Federal Reserve notes are for advances from Federal Reserve institution to another Federal Reserve institution by a Federal Reserve agent and for no other purpose are allowed. And you just sat here and told me I could pay it in Federal Reserve notes. Are you trying to tell me I'm supposed to commit a felony to make this payment?
Oh my God. Like, I'm so nervous. It's the 29th. They gave me time to go over this, and I was going to use that code the whole time that you had told me, but I'm just trying to figure out how I can explain it. I was just going to read it off because they started interviewing the witness.
The United States is owed interest, and me as the principal is owed repayment.
All right.
50 USC 4305, write it out and tell them you're naming the interest in the United States so that they can make sure that the principal, yourself, is fully repaid.
I'm not going to, oh my God, if I have the balls to say this after he goes through this whole witness bullshit.
See, you guys are trying to make way too much of it, and that's the problem.
I know.
You guys are trying to make way too much of it, and that's the problem.
That's what Jason said. He's like, dude, just you don't have to worry about nothing. You're not going to jail. I'm just like, I don't care. I want to fucking try to countersue because I think it's bullshit.
No.
But if you're
Why would you countersue? Why would you countersue? You can't. 50 USC 4305 is a directive for which no person shall be held liable in any court. And under that directive, you place the interest in the United States so that they can guarantee the obligation or other security of the United States, which is repayment of the principal.
Meaning that they're in the wrong anyways, and I'm in the right, so I can't fucking believe that, man. I'm going to rewatch this like 5 times. Come here, Meows. Come here.
All right.
Dude, thank
you. That's
you.
as simple as it gets, folks.
Dude, thank you, Wizard, man. For real. Like, if I can.
You have to realize the interest belongs in the United States. The states.
I have so much shit here. I could send you any tires, bike tires, parts. I really don't have any money right now, but I got a new computer, so I got that going for me. If you need anything done graphic design wise, I can help you out. I really don't have any money right now. So, but I appreciate you so much. Meows, come here. And all your help, man. Seriously. And God bless you. Thank you.
And La India Maria, yes, you shouldn't be entering those courts. But if you are, you have to, there's certain things you should be doing. I don't do those courts anymore. I do all of mine through private communication. And like I said, I let them know. You are not the boss. This is what it says here. And if you want to deny that, I will get you for breach of contract and malfeasance of trust, executor days on tort, for trying to tell me I got to do something with my property. That means you're trying to administrate my property as an executive, and no one's ever assigned you that. None. Ever.
You would say this to the judge or to the prosecutor?
Fucking right I would.
You're so fucking awesome. Oh my God. All right.
I don't play no game. I'll pull up my fucking bicycle driver's license, show them. This has just as much authority as that fucking driver's license you try to pretend I'm supposed to have.
You're intimidating, and that's why I love it. Like, that's I needed the confidence, but I was so happy when he gave me like another chance to go over it. I was like, Your Honor, this is unfair. I have no idea about the 66-page document that you both have, and I don't. And I've saved everything they sent me through postal mail. So I'm showing them on this Zoom. I'm like, do you see all this? And he was like, Your Honor, she checkmarked here that she would accept electronic mail. I'm like, well, why have you been sending me all mail through now? And now all of a sudden you want to save paper?
Yep, exactly. And when it comes to these people, let them know you've got somebody you've been that's been helping educate you.
I've been educating myself too
through his own research, that is willing to come onto the stand and testify. Like I said, I'm not going to stand down to the truth. Yeah, and when it comes to people pulling this shit, you can call me in as a witness.
I don't know if it's too late to do that, but Jay was like, if you need more time, if you want to go over that, tell him you need a continuance. And if that
suggest
happens,
that
dude,
suggest that maybe we get together in private because he really doesn't want to get embarrassed.
Ooh, what?
All of them. Some
Oh,
redneck hick born on the Mississippi with mud squished between his toes is gonna fucking outsmart him.
My God, dude. No, for sure. Yeah, it would be a one-on-one. They went and talked separately. She's from Delaware, so she's like, he's like, Your Honor, I don't think it's fair that she comes in from Delaware because we had this planned, and I'm like the only one that there was like 100 people that started off.
What state are you in?
Chicago.
So they're not even supposed to be coming after you.
Yeah, they're in Delaware. The first one was in Missouri. Midland bought my debt in Delaware. She's
anyway,
Delaware.
I don't need all the details, but yeah.
So she was like, he was like, this isn't really fair because she's not going to have time to come in because they were like, you guys all should start coming into court. COVID's over. I'm like, I'd rather do it over Zoom. So I agree with I'm good with the prosecutor, and he's like, all right, I'll put in a note. And he was like, okay, that's fine. We'll see you June 29th then.
Yeah. All right. Well, guys, I'm going to close it out here. Hey, I do want to thank you for coming up and asking the questions. I don't mean to be pushing off, but I think it is really that simple. Just start hounding him about the obligor and how it's identified by a number. And that proves that you are not liable. You didn't know this, and they're using that as an investment.
Absolutely. I'm going to rewatch this video too, so I can have notes and just have everything written out. And I like you said, I could just preach this to the judge or prosecutor like right there. I don't need to cross examine the witness. It's
no fact, you're just going to put you're just going to let them know, hey, I discovered something that will clarify everything here and let you know that, hey, you better stop what you're doing because the obligor is identified by a number and I happen to know that number. Would you like to know it?
Hell yeah. And I'm going to be confident as hell about it, dude. I'm going to do this thing and I'm going to let you know how it fucking goes, man. Because I'm going to do that because this is bullshit. And you're right. I'm fucking done with this.
And remember, I'm not telling you to do this. This is what I do.
No. But I have done my research and like you're right about it. Like everything you say matches up. So I know you're not bullshitting.
And like I said, if
that you bullshitted on that stamp, I seen that shit, dude. That blew my mind. I seen the fucking how it goes through on the bottom.
I will show them how it all works in their own system. If they don't recognize it, I'll catch them up with the UPU.
Well, I did have a question about that. When you wrote the 1.00 on there or typed it, it looked like a typewriter. What is that 1 cent or $1?
No, that's 1.00, and you know the 1 was uppercase
and the 2
and then on the other side it was lowercase. That's 2 become 1.
Oh, okay.
That's the whole. Everything is measured as a whole, one whole unit, and therefore there's no discrepancy between species. That's why you don't see a $sign on there.
Wow,
it's 1 unit. It's postal unit.
Okay. Yeah, you're genius on this postal union stuff, man. Or postal stuff, man. Gone postal. All right, I will let you.
So anyway,
thank you guys, man. Thank you, Wizard. God bless. Yep. Love you.
Love you too, girl. All right, everybody, real quick, hit that share, like, and subscribe button. Hit that notification bell. Remember, there's another channel as a alternate channel. If you want to go over there and subscribe there, that's Heckle Bus. Heckle Bus, capital H, capital B, all one setup, Heckle-Bus. In the meantime, there's a PayPal button pegged to the top. If you feel free to hit the share, hit the share button there and share some love. Really appreciate it. Hopefully I'll be able to come back with some more videos that I'm going to do as shorts. I plan on doing the Heckle Bus Herald on Sunday night, where I'm going to go back and review my own videos and give some topical points so that we can discuss them on panel. That way we can do any kind of reviews you guys are looking for. I think the first one I'm going to do is on the certificate of title is false in regards to your motor vehicles. I think it's important that people start realizing that when you get those motor vehicle registrations and start signing them license and stuff, you're actually being held to the performance of the functions of public office, and you're not qualified. So we're going to go over that tomorrow night. Heckle Bus Herald. It's going to be a new thing on Sunday nights, 10 o'clock Central Standard Time. I'm hoping to do it just like a little quick half hour to an hour review, just pointing out, like I said, top particular points in certain videos. So we'll see you then. In the meantime, again, please hit that share button or hit that PayPal button and share some love. Hit the share, like, and subscribe. Make sure you hit the notification bell. Let's get the numbers up and start sharing this information outside of YouTube. Start sharing it on other channels and stuff, and get this information out so that more people can take advantage of stepping up to the plate and doing what they're supposed to. And it really isn't all that hard. So thanks again. I love you all. God bless. Have a great night.